Okay, everybody. Time for the last and panel of the day, and also I think, as I said, a very important panel. So, delighted to have the Quattrone Center's Ross Miller here with Iris, Eytan, Tom Farrell, and Cameron Oakes to talk about ethics boards and prosecutorial immunity. We talked a little bit about this yesterday when we had the conversation with Sharif Kuzan and the Thompson versus Connick case. But absolute immunity for prosecutors is something that was created by the Supreme Court in the 1970s, part of a decision called Imbler versus Packman. There's actually a New Republic article that came out today talking about a case that may rise up to the Supreme Court out of the Sixth Circuit may revisit this issue. But in the Imbler case, the court basically said, we get it. When we create immunity that suggests that even intentional misconduct simply has no civil remedy, there is the possibility that we are creating room for injustice. And the part of the court's rationale for that was that there are two other ways that we can hold particularly intentional misconduct accountable. And one of those is, you withhold evidence, you tamper with evidence. Turns out that's a criminal act no matter who you are. And the other is ethics boards. And I think one of the challenges that we've seen is that it's hard to know what ethics boards are doing with the information because there are rules that interfere with that. And when Ross led a study on prosecutorial misconduct, we did a study where basically what we did was we took all the cases that courts had labeled as prosecutorial misconduct going back to the turn of the century, and then we counted them and we tracked how they were resolved. And what we found was that there were, I don't remember the exact number, hundreds of cases in which prosecutorial misconduct had actually been found, and single digits of cases where there had been any ethics actions that were released on those. And so that led to a conversation between Ross and Tom, and I'll let them talk about that. But Tom, we're grateful for your openness to have those conversations. There doesn't seem to be a lot of legislative will to deal with absolute immunity right now. Our society as you may have noticed, sometimes can get a little polarized around criminal justice issues and other issues. And that makes this area of focus that much more important. So I think it's a very important conversation to have. We're delighted to have this group to help talk us through it and the complexities of it. And Ross, I'll let you take it from here. Thank you.
Well, thanks, John. And of course, I should have known better, but now John has made many of my slides. I'm going to start with superfluous. Before I introduce our panel and give them an opportunity to introduce themselves to you, I do want to provide a little bit of a background. We're going to be talking about sort of two big picture things, one of which is prosecutorial misconduct, which at this point, in addition to some of the information that we'll share with you today and we'll discuss in sort of a roundtable format, you've heard multiple accounts from people that are victims of that misconduct and other researchers and other people who have examined that phenomenon and the impact it has in the criminal justice system. And we're also going to be talking about impediments to reform, and primarily what, as John has alluded to, is the most significant, which is prosecutors enjoy something called absolute immunity. So just to give us a baseline for those who may not be as familiar with these topics before we start with our panel, as John said, we did a study it was released in 2020 that focused on prosecutorial misconduct in Pennsylvania. And in that study, which John correctly estimated, we basically looked at over 5,000 opinions that were generated by appellate courts in Pennsylvania over a 17-year period, looked for every case where an allegation of misconduct was made, and then coded those cases to try and find out what happened. This shows you kind of the overall reduction. Basically, there were about 4,600 of those cases that had an actual claim of misconduct. Out of those, only about 3,500 those claims were addressed by the courts, and then it was 145 of those claims where the court actually found misconduct, meaning that they made some determination that the conduct alleged had happened and it was something that was material. Now, to give a larger picture of misconduct nationally, our findings were consistent with reports that have been generated from other states, and you're going to hear about Ohio and Colorado, and more about Pennsylvania today. But looking nationally, another metric is to think about the National Registry of Exonerations. For those of you who may not be familiar with sort of the breakdown of those cases, basically as of yesterday, the total count was at 3,486 cases. 60% of those have some form of official misconduct as a contributing factor, and out of those, you can see there, 53% of those official misconduct cases are prosecutorial misconduct. The rest of them are largely police cases. There are a few more categories. But suffice it to say, prosecutorial misconduct is a significant factor in wrongful convictions and prosecutions across the country. As John mentioned also, specifically, one of the big reasons for that is this longstanding Supreme Court precedent, where we were kind of promised back in 1976 that it wasn't a problem for prosecutors to be immune from suit because they were unique, as it said, in his amenability to professional discipline by an association of his peers. I mean, this was said kind of in passing as though, of course, there will be robust systems in place to regulate prosecutorial conduct. And that's what we're going to talk about today, is how that's going. When we did this study, which I said was released in 2020, which coincides with when Tom became the Chief Disciplinary Counsel in Pennsylvania, at that time what we were able to glean is out of over that time period we examined, there were a little over 3,100 disciplinary actions that had a public record that we were able to actually access, because many of them did not. Well, excuse me, that was a total disciplinary. Out of those, 1,500 were public and half public and private. But only 8 of those involved prosecutors, 8 over that 17-year period, and out of those, only 2 related to conduct as prosecutors. So we commented in the report, this seems like Imbler v. Pacman's, prognostications may not be as accurate as we might have hoped. And at the time said, hey, we've got reason for hope. Do we have a new era? And this is kind of what we published back then, that there were changes being made in real time that Tom's going to talk about, and we're going to find out more about how those have gone since then. But he made some procedural changes that he'll discuss more about and what the impact of those was. And so what the panel today is going to be about is each one of the panelists is going to talk about their expertise and their experience and what they've learned and seen about the state of misconduct and accountability and the potential effects of immunity in the current environment. We're going to then talk a little bit about some of the impediments to reform, and then hopefully we'll have some ideas about where we can look for some positivity in the future. So I'm going to quickly introduce the panelists, and then they're going to each introduce themselves a little more thoroughly as they discuss their experience. But we are extremely fortunate today to have a phenomenal panel of folks that have varied but excellent expertise in this area and have a lot of great information to share. To my immediate right is Cameron Oakes. Cameron is a journalist who covers criminal justice system, healthcare, military and veterans affairs, or has appeared in NPR, NBC News, and other outlets. And most recently with Columbia Journalism Investigations, she completed a very comprehensive 3-installment investigative reporting series on prosecutorial misconduct in Ohio, and she's going to talk to you about that. Tom Farrell, sitting to her right, as I mentioned before, was appointed Chief Disciplinary Counsel in Pennsylvania in 2020, and in that role he oversees disciplinary counsel and other staff throughout Pennsylvania. Before he was appointed to that role, he had served as a public defender in New York, an assistant U.S. attorney in Pittsburgh, and then was in private practice in both civil and criminal capacities. He's also the author of Criminal Defense Tools and Techniques, and co-author of the Third Circuit Criminal Handbook. And we're very lucky to have him here today to talk about what his office has been doing and what changes have occurred in these 4 years that he's been in his role. And then to Mr. Farrell's right is Iris Eytan. Iris is the founding board member and CEO of a nonprofit organization called Protect Ethical Prosecutors, or PEP. PEP was founded to promote ethics, accountability, and transparency for prosecutors. Prior to founding PEP, Iris has been a criminal defense lawyer in Colorado for nearly 30 years, both as a public defender and in private practice. And in the course of her work, in addition to representing thousands of clients, She also identified a number of problems related to the way that criminally involved people with mental health issues were being treated, and so she decided as a separate project and in a pro bono capacity to sue the State of Colorado Department of Human Services, which ultimately led to a 10-year consent decree, a special master to oversee it, and requirements that the state pay $10 million in fees for a year to 10 years in order to remedy some of the problems that she had identified and litigated over 10 years. Through her work both as an attorney and her work through PEP has accomplished many things and has many more things on her plate of what she's been doing in Colorado. So with that, I'm going to stop talking and we're going to get to our discussion. Actually, I do need this. So I want to start with Cameron. Cameron, if you could just tell us a little bit about, I've got up here the title of sort of the first major story that you broke. Ohio prosecutors broke rules to win convictions and got away with it. There have been a couple of follow-ups since then. That code will take you to that story. I highly encourage people after the panel to read that in detail and the other stories. An amazing piece of journalism. Can you just please tell us about what led you to that and what you learned coming, as an outsider to the criminal legal system through that process?
Yeah, thank you so much for having me. Again, I'm Cameron Oakes. Most recently was a reporter with Columbia Journalism Investigations, which is an investigative newsroom that's based at Columbia Journalism School. We collaborate with newsrooms across the country to do in-depth and sometimes cross-border investigative reporting that is designed to deliver impact. Prior to this project, I had never really reported on the criminal justice system from this side of things. I had done some dabbling in military justice reporting, but from the victim side of things, and understanding structures that inhibit victim access to justice in the military system. And so this is kind of like a new adventure for me. I actually was born and raised in Ohio, so it was kind of an interesting opportunity to kind of look back on the community that I grew up in. And what we did, similar to what Ross and other academics have done, was we keyword searched the Ohio opinion database, and we put together a data set of cases where some kind of allegation of prosecutorial misconduct was made. We then tracked those allegations through the court system to understand what happened. And sort of what this overarching article found was that there were more than a dozen prosecutors over a 4-year period who had at least 2 confirmed errors by an appellate court. And that was about out of 104 cases and over 100 attorneys. Now, not some cases only one attorney was responsible for an error. Sometimes multiple attorneys were responsible for an error. And if you click the link and click through to NPR's homepage for the series, there's actually a more detailed article that talks about our methodology and how we identified which prosecutors were responsible and how we sort of like assigned that out, if you're interested. And really sort of the second part of that story that was really significant was we found a pretty striking lack of accountability that's in line with what other researchers have found as well. We couldn't find any documented discipline for the vast majority of prosecutors that we identified through our data, especially for the cases that were like in our data set. And just in general, we went back and looked through the disciplinary records of attorneys over 7 or 8 years and found that it was exceedingly rare for a prosecutor to be disciplined at all. Usually when they were, it was because of some kind of overarching criminal conduct. So in one case, there was a prosecutor who used a law enforcement database to allegedly stalk his ex-wife. So obviously, disciplinary authorities acted on that. And then there was another prosecutor who essentially was charged with forging grand jury indictments. And so he later pleaded down to a lesser charge, but like those were the things that were taken, that the state took action on. And so what we found was like the vast majority of the time, prosecutors, even those with multiple errors, continued to rise in their careers. Some of them became judges and are now kind of tasked with mediating courtrooms that see these kinds of cases. So that was sort of the overarching findings of our investigation. The second story was about Brady violations and a pattern of Brady violations stemming from one county. just for other people who are not lawyers, Brady violations are when the state withholds exculpatory evidence. And like legally speaking, it doesn't matter necessarily whether the prosecutor knew about it. If it's withheld, if the defendant doesn't get it before trial and you can show that, usually it's a Brady violation. And then the third story focused on a doctrine called harmless error, which again, to the non-attorneys in the room, is like a very complicated and sometimes controversial legal doctrine that allows a court to look at a case and say, okay, the state made a mistake or an error, or they royally messed up, but we're not going to take any action as it relates to the conviction. And so we really explored what that means for defendants whose cases are still kind of getting bounced around the system. And like I said, the sheer lack of accountability, I think, was one of the biggest themes of our reporting across the board. And I think to sort of tee up the conversation, especially as someone who's not an attorney, I think one of the things that stuck with me was just how much the fact that the state didn't seem to think they did anything wrong in a lot of cases bothered the defendants. And so one of the people we featured in our reporting, his name is Michael Buhner. He was retried last summer and acquitted by a jury. And he told one of our local reporters in the newsroom after it happened, this is not a direct quote, something to the effect of like, I'm grateful, but I know that they still think that I did it. And that was something that was really hard for him. Like he didn't understand how you could go through the process of retrying a case, losing a case, and then still looking at that person and being like, well, you know, I still think you did it. And so I think that was something that he really struggled with. It's something that I think other people that we interviewed seemed to struggle with. This idea also, I think, perpetuated a lot of anxiety and fear, even for people who had been acquitted, that like people were watching them, that people were waiting for them to make another mistake. I think it intensified fears of police and of authority in general. And I think it was something that struck me in a system where at this time, prosecutors cannot be held civilly liable for the most part for their conduct at trial, whether they mean to commit an error or not. You know, the fact that a lot of prosecutors didn't seem to want to apologize or take accountability, whether that's individually or like as a system, as an office, I think that really struck me because I think the risk, legally speaking, of saying sorry is quite low. So I think that was something that struck me as a non-lawyer and as a reporter who worked on this for almost 2 years.
And again, I just want to make sure people really go and read your reporting because it's the depth and the space that you gave those issues and that you identified those things that, you know, we talk about those things all the time in the system and the identification of harmless error specifically, which we'll talk about later as well, really, really impressive. And so people need to definitely read those articles. And so we'll have some more discussion about that as we kind of move to our second phase. But going to you, Tom, John has set a pretty high bar for us today. So since we kind of started and part of the impetus for this was the work that we did back in 2020 and some of the conversations that we had as you were going into your new role, how's it going? Tell us about the process today and some of the things that you've been able to accomplish or have been unable to accomplish in these last 4 years.
Well, it's been a learning experience. I mean, part of the challenge is through the whole process and the whole 4 years, I'm constantly evaluating what is it that I am trying to accomplish, or my office is trying to accomplish in this initiative. I, at least preliminarily, have concluded that as with many things, the U.S. Supreme Court seems to be willfully blind to the realities of the world, and the disciplinary system is really no place to try to cure, address, or deter prosecutorial misconduct. Part of that is because this is actually one of the reasons I switched from criminal practice to this job. I was a federal prosecutor for 5 years and a criminal defense attorney for about 28 years. I just was tired and sick to my soul of watching people go to prison. People I prosecuted, people I defended, people I became friends with. I've become very active in helping people reenter society. I'm on the board of a couple of reentry organizations. And the disciplinary system, though, very often says its purpose is not punitive. It's not to punish lawyers. It's to protect the public from unfit lawyers, lawyers who have shown that they can't be trusted with the power that comes with a license to practice law. So great, I thought. The concern is public safety and not making a show of hurting people, not of discarding people. Now that becomes a challenge when you're talking about prosecutors. You're talking about lawyers who, many of whom have dedicated their whole career to being public servants. And if they engage in an episode of prosecutorial misconduct, often what you'll find is that is the single, at least known instance of misconduct we're presented with. So the problem becomes, well, what do we do? Do we suspend someone for that? Or do we seek private discipline, which is generally what we do seek against lawyers who've committed the first act of misconduct that's been proven. You all might not know that the attorney disciplinary systems throughout the country are mainly confidential until you get to suspensions and disbarments. The lower form of discipline, admonitions, reprimands, are generally not known to the public. They're kept private. The investigations are private. The complaints are private. There are some exceptions among some states, but most are like that, and that's the way Pennsylvania is. But still, when I started this, I thought, look, I am concerned that this system is not taking seriously the issue of misconduct by prosecutors. And in fact, prosecutors are getting more of a pass than other lawyers are. Sure enough, the Pennsylvania disciplinary system had an internal rule that the only allegations of prosecutorial misconduct that the office would even bother to investigate were when there was a finding by an appellate court of prosecutorial misconduct. Now, that's extremely rare. There could be a lot of prosecutorial misconduct in a case, but when the defense brought it to light, it became a chip to bargain for a much more favorable resolution. So there was no finding. It could have resulted in an acquittal, so no finding. Could have, as often happens, the appellate court decided, well, it was harmless, or they didn't reach the issue because there were other grounds for reversal, and they'd rather not say bad things about a prosecutor. So we eliminated that policy. Second, we did not have in place a practice of checking the opinions to see when a court made a finding of prosecutorial misconduct. So I assigned a paralegal to every week simply check Westlaw for all the reported and unreported decisions in which a court ruled there was prosecutorial misconduct, and then open an investigation on them. And we opened a number of them on that basis. Third, I made it clear to my staff, I'm taking this seriously. Most disciplinary counsel, most of the lawyers who prosecute disciplinary cases in the past had been assistant district attorneys. And they tended to think very highly of their former colleagues. I've been at presentations, one that sticks out in my mind was to criminal defense attorneys, in which one of my lawyers assured the crowd that don't worry, you get a lot of complaints against you, but we don't take complaints by those people seriously. Yeah, who are those people? They're not just inmates, they're generally inmates of a certain ethnic background. So I made it clear that ain't working anymore. I instructed my staff, any case that gets past our initial screening, I want to be made co-counsel on the case. So I get consulted about all decisions and given my background, I can help and helped in the cases. And then I took the show on the road. I wrote an article for the Criminal Defense Lawyers magazine. I spoke to the U.S. Attorney's Office in, I think, the Middle District, Western District, Allegheny County, Pittsburgh DA's office. I live in Pittsburgh and practiced there. Went around to defense organizations and was invited to talk to the Pennsylvania District Attorneys Association about this. I kind of ran the gauntlet by talking to them. Now, I will say that most of the reception from the PDA, the Pennsylvania District Attorneys Association, was warm. They understood. There was one fellow who was kind of hostile, demanded that I should have consulted with them before I did this. And I told him, hey, look, buddy, this is all private. I have no obligation to tell you anything about this. Another fellow wanted to tell me about all the bad prosecutors he had run into as a defense lawyer. But I think it was good to do that. And in fact, we received at least one meritorious referral from the DA's Association, one that resulted in a public reprimand. It was agreed to, the reprimand, but there were offers to testify that what the DA had done was unethical and contrary to good prosecutorial practice. So the results are promising in a sense. I think the system is taking these matters seriously, and I think the message has gotten out about that. I will tell you that the most disappointing thing has been the real dearth of referrals from criminal defense lawyers. We've received some, like I said, one from the DA's Association, a lot of cases we've opened on our own. I counted at least 3 from judges, some from post-conviction attorneys, civil rights attorneys, some from members of the public, but none I could count from the defendant's trial or direct appellate counsel. So the bottom line, over the past 3 years, we received roughly 668 complaints against prosecutors. The total against defense attorneys is about 1,600. So 668 against prosecutors. And now 43 of them reached the stage where basically we thought there was probable cause to bring charges. Now, most of those, 12, maybe 13 of those are still pending. 17 we ended up dismissing because there wasn't a provable case of misconduct. 4 of those we did dismiss by sending a letter of concern to the DA saying, look, you didn't do your job quite right, but given you a clean record and that this wasn't that serious of a violation, we're just sending you this letter. 2, we lost at hearings. One was a close case. We decided not to appeal it. Another one is on appeal to the board, and I was rather surprised by the result. In terms of sanctions, 4 informal admonitions, 1 private reprimand, a conflict of interest situation, which the DA involved then had a press conference about, so it wasn't so private in the end, but we kept it private. I think it's 2 public reprimands. Now, 1 suspension that's probably going to become a disbarment, another disbarment, but both of those were district attorneys who were convicted of crimes, though they were somewhat related to their office. But the lead charges were sex crimes, one an outright rape of someone by a fellow named Jeffrey Thomas was convicted of it. But he had also threatened, there had been separate episodes where he threatened a local magisterial district judge. He had tried to fix a case involving his wife. So there was misuse of his office. Another fellow, Chad Salzman, the conviction was basically for extorting sex from his clients when he was a defense attorney before he was elected. But then when he became district attorney, he tried to tamper with the Attorney General's grand jury investigation of him and intimidate witnesses. So both kind of related to their offices. So will that change the system drastically? I think other measures are required. I've maintained lines of communication with the DA's Association. A few of the folks from that organization are here. I talked to their Ed McCann from Montgomery County invites me to talk to his professional responsibility class at Temple. And I try to sell them on. I think that the organization is serious about improving procedures at offices because that would prevent Brady violations rather than trying to remedy them after it happens. And I think I hope I've convinced some of them that we're not out to get prosecutors. We're just trying to hold prosecutors to the same standards that we hold other lawyers. I hope that's understood. But you know, along those lines, the disciplinary system is a system set up by former lawyers, judges, run by lawyers who both adjudicate and investigate the cases. So it tends to be very understanding of lawyers' misconduct. Certainly a lot more understanding than I hear in my discussions with my buddies, the former juvenile lifers, about the prosecutors they encountered. So you know, it's a mixed verdict. But we'll keep on trying. I think we have to. I think we owe it to the good lawyers, and we owe it to the system, and we owe it to the people to say, look, the prosecutors are judged by the same standards, and because you folks who end up in prison or end up being convicted are often the most scorned of the people in the Commonwealth, it doesn't mean you're not entitled to have your complaints taken seriously, and you're not entitled to have your defense lawyers and prosecutors held to the same standards as other lawyers.
I just want to ask you one follow-up before we move on, which is in the years that you've been there and now kind of having access to the historical data, the numbers that you just provided sounded like that was a big increase over at least what we could see from the outside. But from what you know, are you seeing any change or trend either after your policy or at any other time, or how does that play out from what you are aware of?
We're definitely investigating more cases, and we're definitely demanding a response. There's a certain stage in the confidential process where we send a formal document demanding the lawyer's side of the story, and it's sort of a probable cause stage. We're doing that much more often. And I think even that has at least an educational, if not deterrent value, because now the prosecutor has to get a lawyer and has to explain him or herself. So we are doing that more often. I can tell you the instances of private discipline, it is more than had been in the past. But as you see from the numbers, 43 out of 668, that's about 4%, 4.3% of the cases. Now, a lot of the complaints we receive about 4,000 complaints total in a year, are unfounded. A lot against prosecutors or failure to prosecute someone the complainant wants to see prosecuted. So the percentage itself doesn't tell the story, but yes, we're doing more. I think we're pursuing sanctions, and we're taking the complaints more seriously and demanding a response. And I'm happy about that. And my staff is really working these cases and trying them hard, putting their best into it, and I'm happy about that too.
Yeah, thank you very much for that, and we're going to, of course, circle back to that as well. But now, Iris, I'd love to hear from you about your experience in Colorado. By all accounts, you're a highly successful attorney. You have a long-standing criminal defense practice. At some point, you were motivated to shift your focus to the founding of your organization, protection of ethical prosecutors. what I have learned from you and from your very robust website, which is the folks can visit there. You have a lot of things in the works, and there were a lot of motivations for you to start doing the work that you've done. So what can you tell us about what's going on in Colorado, and what is the environment that sort of led you to take these steps, and what's your vision?
So 30 years of criminal defense. The last 12 years, I experienced significant prosecutorial misconduct committed against my clients. And in all of the cases where I experienced it, they were all high-profile, high-stakes cases. I was convinced when I started being a lawyer that I was working in a system that upheld the words that are actually inscribed here in the archway in this law school, which are truth, candor, and simplicity are the virtues of a lawyer. And I believed all lawyers that I would encounter would similarly work under those virtues. And that also meant prosecutors. And so for, say 20 years, I worked really hard on talking to prosecutors, giving them mitigation, showing them the humanity of my clients, sometimes showing that my client was innocent, giving them evidence. And when I would get to trial, my job was just to uphold the law, make sure that the judge held the line, and make sure that the jury understood that I was challenging, the science or the facts behind the cases. I didn't realize that how disillusioned I had become 2 years ago after years of arguing with prosecutors, thinking that we just disagreed or they just couldn't see the humanity of my clients. I didn't imagine a justice system where those tasked with upholding the law bent it and broke it. And here are a few examples. In 2016, I represented Tom Fallis, who's accused of murder. And during his trial, through a request of documents, I received a copy of an email written by the elected DA and that was between various law enforcement witnesses. And it stated that the DA, could not charge Tom Fallis for murder because the forensics and investigation did not support probable cause. The DA did not inform the grand jury of that opinion, and that he didn't believe the evidence supported probable cause, and he asked for and received an indictment for murder against Tom Fallis. The email was not produced voluntarily, and not until the middle of the 3-week jury trial and a few days prior to Tom's acquittal. In 2019, Micah Kimball was accused of murder. 2 weeks after Micah was accused, the deputy director of the crime lab advised the lead homicide detective and separately the DA that the forensic evidence did not support a homicide. The DA proceeded through a preliminary hearing as if Micah was the only one in the courtroom that believed he was innocent. The emails and opinions were not provided voluntarily, and not until right before Micah was acquitted at trial. And with a few more in the middle, the final blow were not just those 2 cases, it was the recent case. 2022, Barry Morphew was accused of murdering his wife, whose body was not found until about 6 months ago. At the time they charged Barry Morphew, after a year-long investigation looking for his wife and not finding her, they arrested him with a 126-page affidavit signed by the DA's investigator, blessings by the DAs, the elected, and the chief deputy DA, along with the FBI and the Colorado Bureau of Investigation. It claimed that Barry was the only suspect, and all other leads led nowhere other than right back to Barry. Other than the fact that it was read like a tabloid, and didn't seem to appear that anywhere there was any evidence of any kind of murder, what was revealed over the period of a year after Barry was charged was that the affidavit included numerous falsities, manufactured statements, and omissions. The biggest omission was that the DA investigator believed, and the FBI and CBI believed that Barry's wife's car was involved in the commission of her disappearance. And that's because they found unknown male DNA in her car that matched the profiles of numerous unsolved sex offense cases in Arizona. They had not conducted any investigation into these matches. They concealed it. After multiple discovery violations and hearings, the judge sanctioned the DAs for their pattern of abuse for numerous discovery violations, including that they didn't happen to tell anybody about this DNA match, this unknown male DNA, nothing about their search for this alternate suspect that was hanging out there in the balance. The judge ended up saying at a discovery hearing close to the trial date that had that information been included in the affidavit, the judge may not have even arrested Barry Morphew. And 9 days before 1,000 jurors were summoned to trial after the case had been plastered all over national news on 48 hours, and Barry and his 2 children were banished from pretty much the 4 walls of their home because everybody thought Barry was a murderer and his daughters were supporting him in this crime. The DAs dismissed the murder case without prejudice, claiming that they wanted to come back and charge Barry because they believed they found her up buried in a bunch of snow that they couldn't get to before the trial was about to begin. In those cases and more, the DA's excuses were all that the emails and opinions were personal opinions. They weren't favorable to the defense. They didn't need to turn it over. And that not everything needed to be included in the affidavit or presented to the grand jury. After Barry Morphew's case was dismissed, I quit the practice of criminal defense. I've been very emotional here in this symposium with the Sharifs and the stories of the wrongful incarceration, which is what caused me to quit. Too many clients have been damaged, and I can't answer them. How are they getting away with this? How does this happen? How are judges letting this happen? How are they breaking the rules they're supposed to uphold? And I decided that I wanted to use my experience and my currency, especially in Colorado, in reforming the system from the top down. And that is holding prosecutors accountable for their misconduct, deterring them from harming another human being, and compensating the wrongly accused and convicted. So I created PEP, Protect Ethical Prosecutors, and it's a nonprofit. It's a C3 and a C4, aimed at educating the public through a documentary about the unchecked power of prosecutors, as well as the legislative movement to eliminate prosecutorial absolute immunity. Both Jane Byrialson, lawyer for Corey Wise, and Corey Wise of the Exoned Central Park 5 are board members and support really so far the funding of PEP. And the website explains the mission, the crusade, and it's chock full of reports, stories, studies, opinions, and papers that reveal what we all know. Prosecutors have absolute unchecked discretion. They can charge who, when, what, and where to charge individuals without any accountability at all. The public sees them as royalty and the conveyors of the truth. What the public does not know is that 30%, now 40% of exonerations, thousands of Sharice, Chris's, and Jeffreys resulted from prosecutorial misconduct, a majority of them concealing evidence of innocence. It continues because there are no consequences, absolutely none. So the first thing that happened is what John touched on. 1976, Mr. Imbler sues prosecutor Pachtman. You hid evidence of innocence from me. Supreme Court opined that, well, you know what? Even though Section 1983, Civil Rights Action, doesn't write in immunity, it doesn't appear anywhere in the statute, we're going to read it in and make a judicial opinion, basically legislating that it should have been in there. So we're going to give prosecutors immunity because, well, you know what? There is the attorney disciplinary process that will hold them accountable. And also, they could be charged with crimes. So they rationalized that they would be held accountable by other processes already in the system. Well, this 50-year-old decision has now become the law, and it superseded a statute that was silent on the issue. And since that decision, the CODIS DNA database appears in 1998. And since that time, we're able to see that that decision was a relic of the past. We now know the numbers. It's between 0.4%, and that would be the percentage of prosecutors criminally held responsible for acts committed as a prosecutor. That was Ken Anderson, Michael Morton's prosecutor. He went for criminal contempt for like 8 days, went to jail. And then you have the upper end, which is 2% of prosecutors who commit prosecutorial misconduct on the individuals who have been found to be exonerated, that experience either some kind of employment discipline or attorney discipline. That is an abomination. And why the hell would a prosecutor ever do the right thing when nothing is going to deter them? These are individuals, prosecutors, who speak to the legislature on an annual basis about increasing the sentencing for the accused to deter them from future misconduct, to punish them, yet they don't want the same deterrent factors to themselves. So it's very contrary regarding how prosecutors frame this issue. So we know that Imbler, the Supreme Court in Imbler, that now is a relic of the past, right? We've gone way past that. We have scientific studies that show that it's not true. We all know it's not true. We all know that the studies show that they're not deterred, which is why it keeps happening. And the current tools aren't working. And people in the public want to know, because they ask, come on, it doesn't really happen. Why would prosecutors do this? I mean, we see them on TV. You know, they are white knights. I mean, they are carrying the torch. They're making the public safe. And surely, I don't think they are evil. I don't. I know I'm a very passionate person, but I don't. They are good fathers. They are good husbands. They are good sons. They are good friends. They are good neighbors. But they are subjected to cognitive dissonance. They can't admit they're wrong. They can't admit their mistakes. They think they're right. And if they had to admit their mistake, that would shatter them. And they're also subjected to confirmation bias, which is exacerbated by competition, a culture to win at all costs and to get convictions. And this has been studied. You know, it goes way back. Adam Grant, who's, you know, one of the professors here at the University of Pennsylvania, he studies that along with Matthew Syed, who wrote the book Black Box Thinking. And this is not new news, but the public doesn't understand why a prosecutor would do this. And the key is they're not evil. They're just caught up in the fact that a crime has occurred. A crime has occurred. Somebody has died. Somebody was killed. Somebody was murdered. Somebody was raped. And the pressure is on. And a detective comes to you with evidence of some sort, whether it's fabricated or not, and says, this is the guy. This is the guy. And so they take that information and they jump on it and they take it wholesale and they're not going to look back. And they don't look back and they don't apologize, unfortunately. The judges also are a tool, right? So the judges can sanction prosecutors. That's a tool. But in Colorado, we have the most robust Rule 16, I think, in the country. One of the most. And yet, the amount of misconduct that I've seen doesn't parallel that.
Can you just explain what Rule 16 is?
Yes. Rule 16 is a rule that mandates that prosecutors turn over their discovery, police reports, witness statements. And in Colorado Rule 16 requires that material that they have, basically an open file, everything they have has to be turned over within 20 days after the filing of charges, which is usually 10 days after the person is arrested. So very quickly, they have to have the whole case file and turn it over to the defense lawyer, and then everything they receive after that, pursuant to following up their investigation, they have to provide as soon as practicable. Other than the mandated list of items they have to turn over, statements of witnesses, documents, etc., they have to turn over any information that is favorable, that actually, quote, may be favorable to the defense or material to the prosecution. The reason why it doesn't matter that we have a robust Rule 16 is because it's a matter of interpretation. What may be favorable to the defense, usually the prosecution doesn't perceive as being favorable to the defense. So, for example, an email from a homicide detective who's the lead witness in a murder case who says, I've looked at everything and I don't believe there's evidence of a homicide here. The prosecutor didn't believe that was favorable evidence. The prosecutor decided that what that meant to him was, that was his personal opinion. That's like he's sitting Iris. I mean, he's sitting at a bar talking about OJ, you know? He's not talking about this case and the evidence that he's reviewed, the lack of DNA, the lack of blood spatter, the lack of any evidence that, any gunshot residue on my client, the lack of, period, anything that tied my client to a murder. That's what he's talking about, the basis of that opinion. So Rule 16, no matter how robust it is, it doesn't protect the accused from prosecutors' interpretation and their confirmation bias about the particular accused. So the judges, when you raise these issues to the court and you say they didn't provide the opinion pursuant to Rule 16, the judges say, shame on you, shame on you. That's very bad, that's very bad. Okay, all right, Ms. Eytan, what do you need? An extra week? We could set the trial out an extra week. Well, no, because then I'm going to have to call all the witnesses and it's going to cost my client more money and who knows if they're all available. And that really doesn't serve the purpose because my client wants to kind of be acquitted now. So a continuance doesn't really serve any purpose. I know, but that's what we're going to do. The sanctions that the court gives are not a deterrent. And a good example of that is Mr. Morphew. The elected DA, Linda Stanley, in his case, by the time I filed my first motion for sanctions for failure to provide discovery in the case, I gave the court a chart that included 12 discovery violation sanctions in other cases. In her short term at that point, 6 months being an elected prosecutor, already 12 other cases where judges actually sanctioned her on discovery violations. I brought that to the judge. This is a pattern of misconduct. Judge, you do this again, Ms. Stanley, and we're going to be in trouble, okay? So hand everything over to Ms. Eytan. Just 6 months ago, Ms. Stanley was brought in front of the Supreme Court of Colorado on another case where she violated discovery sanctions. The Supreme Court outlined 30 cases, including Barry Morphew's, 30 cases of discovery violations, and was asked to answer the question, was the trial court's order that the first-degree murder charge should be reduced to a second-degree murder charge, is that an appropriate sanction considering the 30 discovery violations and all the other cases that Linda Stanley was overseeing. And actually, the Supreme Court said yes. The Supreme Court said yes, that's an appropriate sanction. But wait a minute. We're talking about 30 known cases, and this is Barry Morphew's case that got dismissed in the middle of the 30 cases. Dismissed because of her misconduct, and she still continued. It is not a deterrent effect. It does absolutely nothing. Zero. So then comes what? So you're left with a judge that judges aren't deterring it. The Office of Attorney Regulation Counsel in Colorado actually is filing a complaint against Linda Stanley. But that is very rare. It is extremely rare. I have contacted the Office of Attorney Regulation Counsel about all these other DAs that I've had to encounter, and it's very rare that defense lawyers want to come forward. And that's been Tom's experience. And they don't want to come forward because they're scared of retaliation. They're concerned that their other clients are going to suffer maybe negative consequences, plea bargaining as a result of coming after them in a particular case. And also, it takes time. It took me a year to write the complaint against the 7 prosecutors in the Morphew case. It took me a year because I knew that if I didn't write it with all seriousness and with details and with 134 detailed exhibits, that it would go nowhere. So and she was, 3 of the prosecutors are now facing official complaints. Their hearings are public in Colorado. But it's rare, and the reason why I think that OARC went that way in Colorado is because it turns out from OARC's investigation that the prosecutors had it in for the judge. After the judge ruled in Barry Morphew's favor that they violated discovery sanctions, they came up with some text messages between the prosecutors, the 3 high-level prosecutors, that said, the judge must be biased against us. You know, we didn't do anything wrong. He must have abused his wife, and he likes domestic violence offenders. And we see this petition by this true crime podcaster, and it says that he beat up his wife. So let's go talk to his wife and get him off this case. And the quotes from the text messages are, let's get him. So they're all now facing hearings. And I think had it not been for that extreme of behavior, these prosecutors wouldn't be facing any kind of discipline. I just don't believe it. I don't believe that the discovery itself would have gotten them this far. So the result of this is these tools aren't working. It's continuing to happen. I haven't seen any kind of deterrent factor. And the studies all say that immunity is the way. Immunity is at least it's a tool in the toolbox. At this point in the United States, if you get a hot chicken McNugget that lands on your leg, you can get $800,000 from McDonald's. Okay? All right. If you're a doctor and you botch a surgery, you can sue the doctor, right? If you're a criminal defense lawyer and you don't tell your client about a plea bargain that they might have wanted to take, you can be sued, right? But if a prosecutor hides evidence of innocence and locks you up for 30 years for something you didn't do, you can't sue the prosecutor. For intentional misconduct, reckless behavior, and the public that does know about this, as the studies show, they think that's wrong, and that needs to change. And so there's no question that that's the movement. And the movement in this direction, I've started it both with PEP. My first round after Mike Kimball's case, I tried to pass the legislation to eliminate absolute immunity. Many reasons why I got bogged down and didn't get out of committee. But, the DA lobbyist quotes were, this doesn't happen in Colorado. IRS happens everywhere else but Colorado. And you had one bad case You had one bad case. So, don't be bringing in, your bad case to make legislation surrounding one bad case. And we have a great Rule 16. Okay, that was the response to that. So after Morphew, I then created this, and you'll see the photographs and stories that are highlighted are Colorado cases. I know there's an in the news tab, and it goes back 4 years and highlights every single news article where there's established prosecutorial misconduct across the country. Every study, every article and opinion ever written about this issue gets to the same similar focus, that absolute immunity is barring us from being protected from prosecutors that commit misconduct.
Well, let me,
I haven't done it yet.
We were going to be discussing like some of the impediments and problems in getting reforms. You've covered a lot of those in your discussion. And I want to, one thing that you mentioned, and I want to kind of cover this area briefly so we can get on to like what does the future maybe look like, is the difference from a transparency perspective in a case where there can be litigation. Like anybody can sue anybody for anything, kind of, except for prosecutors, right? And if you look at all these other avenues, there's something unique about prosecutors, not just in the absolute immunity, but as Tom talked about, I'm going to ask you to clarify for the audience because we had a question about it. There's a very high level of confidentiality in the complaint process, interestingly, in a system designed by lawyers that's specific to lawyers that kind of nobody else has. And so we always talk about, sunlight is the best disinfectant and these kind of things. And to the extent, if we can assume that there's some value in transparency and whatever that affords, that's something that would be different in a world where you have the ability to litigate cases against prosecutors versus the one that we're in. And so I want to ask you, Tom, the kind of reasons for that, or like first to clarify for the audience what the confidentiality is from your perspective, why you can't disclose certain things and what you can disclose, and then from your perception, what that, the difference is between what you have to evaluate versus what might be a perfectly legitimate claim in another forum with another set of rules, sure, but things that are never going to see the light of day because of the way the disciplinary board operates.
Sure. On the confidentiality, it's the rules that are set by the Supreme Court and Supreme Courts around the nation that attorney disciplinary investigations are confidential. They're non-public. So from complaint until the system, we were allowed to seek a suspension. The investigation is confidential and never can become public. Also, we don't have in our system the discovery tools, the substantial discovery tools you have in civil litigation, extensive documentary discovery, depositions. We don't have deposition power. So we're not we don't have those tools to bring out evidence. I'm sure Iris will talk about it. Absolute immunity ends a case before discovery. It's a motion to dismiss issue. So often that cuts off any discovery in a prosecutorial case. Second, we don't have any jurisdiction over firms, law firms or DA's offices. So we can't seek to investigate or discipline the DA's office for having a bad culture or having bad policies that are leading to this. I mean, third, our sanctions, remember, are not against offices, and they're not felt by the taxpayers of the county. We don't get damage awards that the taxpayer next election time can say, I'm not electing this guy because our taxes went up to pay that $10 million settlement or verdict. And often, we're disciplining, investigating and disciplining prosecutors after they've left the office.
Right.
So the office doesn't care about them, and often does not care
Right.
about them, especially if there's been a change in the DA's office. So that's a number of reasons why there isn't that disinfectant in our system. I mean, I'd love it in the criminal justice system if the Constitution prohibits it. The whole phase up until conviction is confidential, so if someone's acquitted, their reputation is protected.
That's right.
But we do that for lawyers in the disciplinary system. Might be a good thing, but it's an advantage other people don't have.
Yeah, and I want to, this transparency theme, Cameron, I want to ask you, we had a conversation sort of in advance of the panel talking about, everyone talking about their experiences and thinking about how to translate some of this. You brought up something something Iris said really reminded me of it, that feels like it's a big part of the impediment here, which you talked about prosecutors and sort of court systems using a lot of restorative language, in their processes, sort of marketing those kinds of programs, but what seems to be a complete unwillingness to apply any of that to themselves. And that's something that came out of your interviews and your observations. Can you just tell us a little bit about that, like that kind of theme that you picked up on?
Well, yeah, and also just to Tom's point, that makes it really hard for journalists to do their jobs. We did obtain confidential letters from Ohio's Office of Disciplinary Counsel, but those were leaked to us. And if you're an attorney and you do that, you risk discipline for doing that. And so there were people who, for one reason or another, elected to make those available to us. And so, if you do file a complaint, I can't tell you what to do with that information, but there are alternative ways that we have to get things. Occasionally, we got them through very creative public records requests, but it's not like you can just log in. I mean, you can see the docket, but you can't log in and get a bunch of documents unless it gets to a point where there's public-facing discipline. Other professional organizations, doctors, also have a very secretive process for early complaints as well, so it's not necessarily unique to attorneys, but it is a problem with accountability. In terms of the restorative justice thing, I think it's just much more that when we were having conversations with legal and ethical experts about what the solutions are and where we go from here, a lot of people said, we don't think that everything needs to be disciplined. We don't think that a junior lawyer who accidentally invokes a defendant's right to remain silent in closing arguments should be disbarred. That's not appropriate. But that doesn't mean that there's not other steps that need to be taken. And I think that really struck me as a reporter. It kind of mirrored a lot of the language of the restorative justice movement, right? That not everything needs to be punitive, that not everything needs to result in your career being over or you not being allowed to do the work you want to do. But there still needs to be some accountability that's taken. And it just struck me that that's not something that's afforded to criminal defendants oftentimes. And I think to Tom's point as well, people's lives are ruined even if they're never convicted, if they're arrested, if they're paraded around in public. And they can never, even if they're exonerated later on, can't really escape that public image of things. And I know that can be hard for people, knowing that their image and likeness is everywhere, forever, on the internet. And so, it's just interesting that the system is really eager to provide that kind of cover, reputational cover, and protection for attorneys, but we don't turn around and provide that same protection to the vast majority of criminal defendants. And as a reporter, it's not my job to say whether or not it should or shouldn't be that way, but I think it's just something that struck me as very interesting and kind of a dichotomy that didn't feel well resolved through the reporting.
Yeah, and something else that you talked about, your separate piece on harmless error. And when I saw that, when we tried to do our coding, we had a field, we're going to code these opinions for harmless error. And what we found is, in Pennsylvania at least, judges don't use those words, but that's what they do. That's what the opinion ultimately is. And, this is another way, so we sort of talked about how the disciplinary board process has limitations that are not allowing people to be made whole, kind of in that concept that we have in the law. And then the other path that exists are these claims and, misconduct claims actually going through the court system. But harmless error, from our experience, seemed to eat a lot of those cases, that notion. You picked up on it to such an extent, you did a whole separate piece on it. What's your perspective on that, or sort of how did that emerge as such an important an important characteristic of the cases?
I think we just realized early on coding the cases that to see a case reversed, even for a hearing, was just exceedingly rare. We didn't really see it that often, and usually it was coupled with like some egregious form of a violation of somebody's rights at trial. And so there were all these cases where people would say stuff that, like, as a layperson, you're like, wait, you invoked the Bible during opening arguments to say this person should go to jail, and like, you know, nothing happens as a result. Or you know, there was a case that was featured in the first story where a prosecutor basically told the jury to like imagine people coming up from the grave, or that if they didn't convict someone, they were sending a message to victims, which are like all things that courts have pretty clearly said you can't do. And so, but oftentimes when they review them on appeal, they kind of look at it and they say, well, okay, like, this was bad, you shouldn't do this. But also, like, this person is probably guilty, so, you know, we're not gonna do anything about it. And that story was really kind of a rabbit hole for me of like understanding where this doctrine, this harmless error doctrine came from. They don't always use the word harmless. There are lots of phrases that we had to like become attuned to. But there's a debate about whether or not weighing evidence of guilt versus the error itself is like even the correct way to apply that standard. But basically what we did was we went down a 120-year-old rabbit hole to really understand like where this doctrine came from and the confusion about it. And I think if you were here for the panel where they were talking about how junk science kind of got replicated through the appellate system, I think we saw kind of a parallel thing happening where one Supreme Court case would like clearly explain how harmless error is supposed to be applied, and then a few years later there would be another case that seemed to kind of like contradict it a bit, and then like one court, you know, kind of picked it up and kept using that same definition and just like ran with it. And so like, I'm not a legal expert. Legal experts also debate like the appropriate usage of this doctrine and who's interpreting it correctly. But I think it just became, practically speaking, a way that we saw cases were getting just thrown out. And there are prosecutors and prosecutors' offices who have the attitude that a harmless error is not really an error, especially if it's like an error that's kind of a technicality and not something that was intentionally done. So I think we just saw it was kind of another way to sort of skirt accountability in the system, and not necessarily individually on anybody, but just a way that the justice system was just like disposing of these cases and being like, okay, well, this person probably committed this horrific crime, so like the fact that at multiple points along the way the state didn't really play super fairly, it doesn't matter. And so I think that's sort of where our interest in that came from. And I think it was an attempt by us to really explore what that means for folks. And in that story, you can see that there are 3 people whose cases are very much left open-ended and who don't necessarily all have the resources to do anything about it. So,
can I say something about the harm? I mean, a harmless error, the idea is that you don't want to overturn a conviction for an error if there was overwhelming guilt that would have proven guilt even absent this error. Now, the effect of it is often if it's that kind of case, the court won't address the error because harmless error says there shouldn't be a conviction, there shouldn't be a reversal. It bleeds into my system too. I see it as well, especially the issue where it most often comes up is misconduct in what the prosecutor argues or states in opening or closing argument. Where often the reaction of hearing committees of the board is, well, kind of twofold. Well, it didn't result in a reversal, so, you know, what's the big deal about it? Maybe he shouldn't have said that, but it's not a big deal. And second, even in our system that's not supposed to be adjudicating the underlying guilt or innocence, if the adjudicators feel, oh, well,
he did it.
Yeah, the prosecutor did something wrong, but this guy was really guilty, even in cases that get dismissed. But he was really guilty. They're not very eager to discipline the prosecutor, we find.
Yeah. So, you know, all right, well, we kind of covered a lot of ground here. We talked about these impediments of discovery being insufficient, existing systems being insufficient, the disciplinary board process being sufficient maybe for one purpose, but not holistically for resolving these issues of misconduct, and then the sort of direct litigation path. There are a lot of impediments there. And so you mentioned the studies, Iris, so we'll talk about one of the studies at least. we at the Quattrone Center, kind of investigating this, are always trying to think about how we can make change, right? As we observe these things, and ideally we can study them empirically, we can do things to generate knowledge about things. And so one of the questions we had that you've already kind of intimated at the answer to from your own observations is that people, when they know about this or understand it, sort of don't tolerate it or aren't receptive to it. And so just, I think what you're in part referring to, we did an opinion study that was a survey, nationally represented survey, and we found this was an area with very high agreement that in a case where they were presented with something that was based on the John Thompson case, where there were two conditions, an intentional condition where the prosecutor intentionally withheld something, and another one the prosecutor didn't know the evidence existed. And we found that 87% of our respondents said there should be liability, there should be the ability to sue in the intentional condition, and 67% said there should be in the unintentional condition. And so the next question is like, okay, well that's like, people are thinking about this from a criminal justice lens, and it's like, but that surely there's this dichotomy in the American population. We live in the most polarizing times, at least those of us that are currently here can remember. And from our study, probably one of the most fascinating things was we found total agreement between, one of our variables was people who had voted for Hillary Clinton in 2016 and people who had voted for Trump in 2016, and very little difference. You see there 92% yes for liability and intentional, and 88% yes for liability and intentional. So this is this rare situation from our perspective where we have something that seems to be a place where people can agree, a place that's not controversial from a public reception standpoint, and yet it appears to be the place where it's been the most difficult, if not impossible, to advance the ball at all. And so my question now is, I don't want to say why, because that gets us too far afield, but what do we do? If this is true, and let's just assume this study, and you could replicate it and say in every state you could find things similar to this, that in general people think that they should be able to sue. How do we use all the information that we have and that you've discussed about the insufficiency of current systems and what we think we know about the public's view about not having that? What do we do with that information to actually start changing the status quo relative to the presence of absolute immunity?
Anguish to action, right?
Yeah, exactly.
Okay. So the action, I think there are two things, okay? Two. Other than immunity. Hold on a minute. Before immunity, one of the action items that can be used to prevent wrongful convictions. So to help eliminate the need for conviction integrity units 40 years from now, right? That would be the goal. Let's put all these people out of work, right? So we're not continuing to do this. One way is to amend the rules, the state rules, like Rule 16, for example, right? And it would be to, one, describe what favorable information is. What does it look like, right? So there's no interpretation. That's one little thing. Another little thing is in Rule 16, usually across the country, when there's a mandatory production of documents, it says you must provide documents and statements of witnesses. Well, judges don't interpret that to be emails and texts, which is the way that we all communicate now. That's how we all make statements now. That's how witnesses talk. That's how cops talk to prosecutors. Cops talk to cops. It takes endless amounts of time to litigate that and make that request and to get that. And in every one of the cases that I have had where there has been prosecutorial misconduct and hiding of evidence of innocence, it exists in the emails and texts between the witnesses and the prosecutor. So if I'm right, based on my own anecdotal experience, a rule can be changed to do that. Third thing, the third little tweak, before you even get to immunity, publicize the name of the DA who the judge find make a Brady violation. Publicize it. Put it in a database that is accessible so that every judge that is seeing that prosecutor before them and or a defense lawyer who's coming into court can look up on the database and say, kind of like similar to a Brady database that they have for cops. You can say, oh, interesting. Such and such DA is committed, has been found to have violated discovery rules in 5 other cases. So when this defense lawyer is getting up saying, I didn't get such and such, maybe I should take a look at that. Or maybe there should be an extra, sanction if it's in fact true, so that they don't keep getting away with it. There's a knowledge base. We have transparency about that. And then, of course, the biggest thing is immunity. And I think that it needs to start. I'm doing it in the Morphew case. My team sued 22 defendants in the Morphew case, including the prosecutors. Because, as I mentioned, the signature of the affidavit was an investigator for the DA's office and 2 DAs. Prosecutors have qualified immunity, meaning they can be sued. There's 2 factors to that. If they're involved in investigation prior to them filing charges. But it's very rare for prosecutors to be involved in the investigative stage of a criminal case. It's extremely rare. Usually it's police officers that bring the case to the prosecutors. The prosecutor might say, hey, go talk to this person or that person, might be very limited. And then the prosecutor takes the case forward. When an individual is charged, that's usually when absolute immunity applies. Period, end of story. They could lie, cheat, hide evidence, and nothing happens to them, intentionally, recklessly, knowingly. And in this instance, immunity, we are challenging it in the Morphew case. The absolute immunity, we have filed in our response to our motion to dismiss, because we haven't gotten to the discovery yet. We filed our complaint. The defendants filed their motion to dismiss, and we filed a response. And in that response, we asked the federal judge, look, this is a relic of the past. Eliminate absolute immunity. Let us stop this blockade from happening. Hold these prosecutors accountable. And so that's one way, is to start litigating that in federal courts while you are suing the cops who are depending qualified immunity. In Colorado, in state court, cops aren't even qualified immune. They have no immunity anymore, right? They are completely open, and they have to pay $25,000 out of their own pockets. They have skin in the game. And that's what we're asking for in Colorado as a start. So prosecutors, not $25,000, but $50,000. $50,000, and that might provide enough deterrence for them to say, I know I don't really want to tell anybody about this DNA because, I don't think the DNA means anything, for the first time that, DNA has come along. I don't believe in this DNA because it doesn't have your DNA on it, Tom, but okay, $50,000, okay, there you go. And so it could, I'm not saying it's an answer to, but it is a tool in the toolbox to prevent prosecutors from concealing evidence of innocence. It could curb prosecutors from making the wrong decision and instead making the harder decision for them to hand over evidence of innocence.
Yeah, Cameron, from your experience talking to the people affected by this directly, did you get any sense of what remedy that would actually make them feel like they got some sense of justice? Like if they could have that kind of action and be able to sue the prosecutor or at least make that a more public process, is that something that would answer to that, or what was it that you think people wanted to have happen?
I mean, I think, to be honest, knowledge about whether someone has civil liability is kind of for people who have been incarcerated since they were teenagers and stuck in a prison and recently got out. I don't necessarily think that's always a top of mind thought. Ohio does have a wrongful imprisonment payment program, so people have been paid for their time being wrongfully imprisoned that way. I will say that it does have limitations. So we did speak to someone for the Brady story who pleaded guilty and probably would have gotten a retrial, but basically elected to take a plea deal because he wanted to get home to his daughter, who was 4 years old. And so that barred him from any kind of compensation. And of course, that's still on his record. And sometimes people like really think about it holistically, like they're not sitting there thinking that the prosecutor is the only person responsible for what happened to them. But I mean, I think it's a struggle for folks. I think people want accountability, and if I can just say what experts have really pointed to Irish's point, naming prosecutors in decisions, the names that came up through our stories were all done by shoe leather. Almost none of them were named directly in the opinion. We had to do the painstaking work of tracking down every person that touched the case from start to finish. We had to reach out to those people for comment. And so a lot of experts have suggested that putting that in the public domain would make a huge difference, and that there's a lot of shame in the legal profession. Can't confirm or deny, you guys can let me know, around the prospect of being named and shamed by an appellate judge in a decision. Again, people have suggested things like internal databases that are short of discipline but can track behavior over time for disciplinary authorities and for appellate judges to see if this is a pattern of behavior. And like I said at the start, like I do think acknowledging systemic failures goes a long way. And I think for a lot of people that's probably not going to be enough. So yeah, I would just say that as people kind of spend more time out of prison, and people who are still litigating their cases, like I think giving them the space to like really think about it and think through it on the other side will become really important, because I think asking people in the heat of the moment, like, what do you want to see happen, is really hard. Sometimes they don't always, it hasn't been the top of mind thing, you know. They've got a million other things to worry about that are not like necessarily immediate accountability.
And they're living in a world that doesn't exist, so it's
well,
not
there's
top
that.
of mind.
Yeah.
Too.
And you know, I think like people don't know, like a lot of people don't know that the members of the public can file a disciplinary complaint against a prosecutor. Like that was a huge thing. Like we talked to people who were like, oh, if I had known, or people who did file a complaint, but the disciplinary system said, well, you don't have an appellate finding of misconduct, so get back to us if that ever happens. And they just, again, these are people who are really distrustful of the system, and so they were like, why would I file it again? Like, you didn't take me seriously the first time, and I have bigger things to worry about in my life. So I think there's a lot of like structural hurdles to accountability, and so I think like sometimes it takes folks some time to really think about what they want and what would benefit them in the long term, and not just like immediately.
Yeah, and Tom, I'm going to ask you the same question with a slight modification. We had several audience questions that actually were sort of anticipated by some of your responses. So if I didn't ask specific questions, I think you heard the answers to them in some of the responses. One of them, though, was about, well, can't we do this with FOIA? Like if we just had expanded the ability, FOIA, the Freedom of Information Act, or, you know, the ability to just get information, which, of course, we in the legal field know has a lot of limitations itself. But thinking about your role, even in a world where we had 50 Tom Farrells, so every disciplinary counsel was as, you know, holistic about the process as you were, and with the limitations of what those offices can do, does expanded, like, how do we think about the idea of litigation through the ending of absolute immunity, through the tools you talked about, discovery, depositions, which is a big one, versus just additional or expanded public access to records for officials?
I mean, it's hard to say how effective that would be, because it's not going to happen. You know, disciplinary authorities are part of the judiciary, and generally in Pennsylvania it's the case that the FOIA, state right to know laws, do not apply to the judicial branch. So you can't, you wouldn't get information out of us. Yeah, we do have debates. I think there's at least one state that opens its system from the very start, from as soon as a complaint's filed to the end, whether it's dismissed after a week or whether it ends in disbarment. And you know, yes, we're trying to protect the reputations of innocent lawyers, but doesn't a dismissal do that? There's a lot to be said for that. In choosing a lawyer, wouldn't you want to know that there have been 10 complaints over the past